courthouse the other day in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
All right. Time for Justice Serve TV to be called to order.
I want to let you all know I'm under Kenny Biden. That I think is Michael Bryant, but he didn't show
Today,
me that. He didn't show me that he was going to be Rumpo on the Bailey.
The Honorable Michael Bryant.
The Honorable Rumpo on the Bailey when he did this. So, okay, well, I have a Halloween. It is Halloween before we get it. I have a Halloween. I have Halloween costume too. Okay. I am pretending actually to be a baseball player. I'm pretending to be a New York Yankee. I try to pretend there because my Jets went down the hill. And then my Yankees went down the hill. So I'm wearing like this, this baseball shirt. Oh, and there I am. I'm also dressed for Halloween because you see this.
Oh, I see some pumpkin heads there.
I can't. Well, pumpkin.
Oh, and a spider.
There's a spider. I'm going to lose my earpiece here taking this off. But just hold on. Bear with me. Don't go away. I'm going to take this off. Not that. I'm going to take this off. I'm going to put my earpiece back on soon because you can hear me.
Yeah. Ms. Kenny Biden, please.
Right?
Come to order.
It's like a pumpkin. Please. I'm wearing Tubi's pumpkin. Tubi's are my dog. I'm wearing a spider. I have even this for you, Michael.
It's out of order.
I have even this for you. Another thing, and because it's Halloween, I have candy for everybody, but I don't know how to get it to all of our viewers. Okay,
that is a problem.
And I have one more thing, but I'll use it when we talk about what we're going to talk about, which is the case that's going to start. Just really quickly, what was it? What am I upset about, Michael?
I'm trying to remember. Is this the Missouri case about the signage?
This is it, about the sex offenders. You want to talk about it? Or you want me to lead it?
Oh, go ahead. Go ahead. Okay. I got a Halloween story of my own. You go ahead.
So looking through, my assistant, Pat Holbert, this morning was looking through like media stories, and here court ruling changes requirements for sex offenders on Halloween. It's out of Columbia, Missouri. The Missouri State Supreme Court ruled that the law enacted in 2008 that said that a sex offender, now this is an adjudicated sex offender, had to post a sign in his or her residence stating, quote, "No candy or treats at this residence," close quote, was unconstitutional because it was forced speech. So sex offenders don't have to post that sign. They do have some other requirements they have to do. But I'm telling you what, I have, in addition to my spider, my orange pumpkin, my pumpkins, I now have, just like you, a baseball bat. Okay?
Just like me.
Just like you, because I'm pretty upset about this whole deal. Okay?
So basically this is a relaxing of the sex offender requirement to, I guess, point out, by the way, I'm a sex offender, so don't come here for any candy, and kids, stay off my property. But the signage itself doesn't identify them as a sex offender. It's just something they are required to do as a sex offender, correct?
Right. Correct.
Okay.
Right. Okay. So anyhow, we see from some of our viewers that the YSL is live right now.
I just turned it off. Of course I did.
Of course you did. Okay. So we're going to be talking about that. We'll be following that as we talk about some other cases going on here. So maybe we should lead into that and see what happens on YSL. We're just going to kind of reverse what we were doing with you all, saying that somebody may take a plea. Okay.
Who could it be? There's only 3 left. For those who obviously haven't caught up yesterday, 2 more pleas. Now we're down to the 3 that are left: Shannon Stillwell, and Gotti, of course, Mr. Kendrick, and of course Jeffrey Williams.
That's right, and he's the one.
He's the only 3 left.
He's the one, apparently, and the plea negotiations ended, according to Thugger Daily, and that he's about to take a non-negotiated plea. But he needs a moment to think it over. The non-negotiated plea means the judge decides the sentence, not the state. Okay. That's different than in most states. Most states don't have something called a non-negotiated plea. Okay.
Who'd you say this is for?
For Jeffrey Williams. This is for the big guy.
Target defendant.
Yeah. So usually what that means, sometimes when you can take a plea and the state doesn't recommend the sentence, you normally have a wink and stuff by the judge as to what you're going to get. Like, and give you this, and you decide to let your client roll the dice and figure out that that's what the judge is going to go. But apparently, he may take a non-negotiated plea. So we're following that as we go. As I'm watching it, actually, you are watching it.
That was interesting,
Yeah.
because again, he's the only defendant without any sort of record of any kind.
Right.
We
And
know,
I don't think any evidence of any kind either.
well, we know Fonnie Willis is set on the whole RICO thing. So, and we also know that's a max 20 years, right?
Right. Right.
Would he take a RICO felony conviction, even if it was basically for time served?
I don't know. That's a really hard one because then they're going to be after him all the time. Because he's a lot of things he won't be able to do, and it's being announced in court that they did reach an impasse. That they reached an impasse with regard to sentence. So they obviously had agreed upon what it was that he would plead to. Okay, but they've reached an impasse as regard to sentence. So that's what I see right now. I'm not sure what the judge is following up on that right now. His attorneys are speaking with him. It doesn't look, I tell you, as I'm watching it, it doesn't, and Michael, you should turn it on, even if you're on your phone. I know this is not what we had planned for this show, but that's what happens at 4:00 on Halloween, okay? With Michael Bryant in a wig looking like, yes, he looks like George Washington, but he's actually—
Hey, this comes from the wig shop in London, where they make all the wigs for the barristers and solicitors. I'm sure everybody knows in London and in the courts of England that there are barristers who are the folks they'd be the equivalent of trial attorneys here, and then there are solicitors, which would be the equivalent of transactional attorneys here, bankruptcy and patent law and mergers and acquisitions. Anyway, so they still are required to wear wigs in court even today. So I went there many years ago. I go to the wig shop. It's a well-known wig shop, and I'm talking to this woman about these are all horsehair wigs, and she said, yeah, I just came back to work. And I said, oh, you were on vacation? Or she said, well, sort of. I took 18 years off to raise my kids. And now I'm back. So 18 years ago, she was in the wig shop doing the wigs, and it takes about 2 months to make them. And then she left for 18 years, got her kid out the door, came back to the wig shop.
Yeah.
So,
well,
amazing.
That's really that's kind of incredible. But when you're talking about 18 years, at least she was raising her kids. We're talking about 18 years or 14 years or 18 years or 10 years in the Young Thug case and the YSL case on probation or doing time or something like that. That's a whole different story here. It's being reported that Thug's family is in the courtroom. Okay. It is in the courtroom. I just do not know. Does any of our viewers know what they have said, whether they've said what it is that he wanted to plead to in this non-negotiated plea and roll the dice with the judge? All I can think of is that Brian Steele has what he thinks is a promise from the judge of what the sentence would be that she would give if it's true. That's all I can think of at this point. And maybe it's time served. Maybe that's what it is. And then he walks out. With regard to expungement, every state is different. I haven't looked up what Georgia allows an expungement. I know in certain states you can't expunge a felony. Other states you can expunge a felony. There's a lot of different things. And so we'd have to look that up. I can't answer that question because I don't know the answer to that question.
And we're still hearing from our buddy Doug that any deal that they have been offered and countered and offered again that's all been rejected. So no change there. No change there, and also that if he was going to get a mistrial, which he probably believes that he can still get at some point, he wants it with prejudice, not without prejudice, which is what the judge offered to give. So but we'll see what happens here with this. This is something that we didn't expect here today, even though we've all been following it, right? Here. I checked just before we went on, and it was the usual test pattern. So
right. So we'll see. You want to, while we're watching that, should we talk about the other case?
Okay,
You see
yeah.
the-
This is it is a Halloween case, but it's a case with a happy ending. It doesn't have such a happy beginning, but does have a good ending. Let's see if I can set some music here. Okay, you ready for this?
Yeah.
December 1st, 1982, at approximately 8 p.m., two animal trappers call authorities. They have found a body. The top portion of the body's head was missing, as was an area by the ear. The skin was a grayish color, with the body being slightly decomposed. An identification card was found for Clifford Smith. During the autopsy, it was discovered that there were many pieces of buckshot in the head of the body. The death was attributed to extensive brain damage sustained by a shotgun blast to the head. It was further opined that the gun was fired with the barrel inside the mouth. So, was this a suicide? Was this a murder? This is 1982. So, kill my spooky music here. With the help of a report from WLKY in Louisville, Kentucky, which is where this happened, I think we can see there's at least some resolution to this story. I will pull this up for you here. Again, this is a story that has been 4+ decades in the making here.
Halloween night in Rockford, Indiana. Much as it was 41 years ago. Kids ready to trick or treat. Adults ready to party. But one gathering of friends and relatives way back in the early 1980s ended in death. According to court records, Clifford Smith was murdered on Halloween night in 1982. His body was found here in rural Jackson County in a swampy area just off the White River. Investigators say they found the body in a small pool of water. It was partially decomposed. Part of his head was missing. But when investigators reached inside the jeans of the man, they found an identification card and identified the victim as Clifford Smith. The grim discovery was made near the intersection of these county roads just north of Seymour, not far from this now abandoned skating rink, which sits on the banks of the White River. In 1982, police determined 24-year-old Clifford Smith died from being shot in the head, but thought he may have come out here and killed himself. No arrests were ever made. But in 2015, state police reopened the case, and now, 41 years to the day after Smith died, an arrest has been made. 61-year-old Ronald Anderson, Clifford Smith's brother-in-law, is the alleged killer.
In this case, it was a lot of, fresh eyes looking at the case and new detectives taking a look and going over the case that was originally investigated all those years ago.
That investigation determined Anderson, known by the nickname Space Monkey at the time, was at a house with Smith and others on Halloween. Anderson and Smith left the house together, but not before police say Anderson grabbed and loaded a shotgun. Smith was never seen again until his body was found in this flooded field. An affidavit points to arguing and drug use as possible motives for the crime. Anderson is being held at the Jackson County Jail. The family of Clifford Smith now has answers to a 4-decade-long mystery.
Ultimately, that is our goal, to owe it to those families, to let them know that we've solved the mystery of what happened to their loved ones.
So, spooky, but a very, at least positive step in the right direction. And this was weird because it wasn't like DNA, from the modern day, made up for the inadequacies of the 80s. No, it was, as the reporter said, and thanks to WLKY, it used to be my affiliate with the Legal Edge back in the day. They just kept pounding the pavement. And it sounds like and I'm reading the probable cause affidavit, there was a lot of information about the fight within the family and the extraneous friends that were also part of this fight, and the interaction between the Space Monkey, the defendant, and the decedent and his wife made it pretty clear that it was in that little group that something wasn't right. I think it's a little odd that it went decades before somebody fleshed it out, but certainly for the relatives of Mr. Clifford Smith, good news for them, albeit 40 years after the fact.
Right, and I'm sure that Mr. Anderson didn't look like that at the time that this happened. It's very hard when
No,
the old
no.
case is 40 years old, and you think that they could have gotten into that fight and shot him in the head over something, just it's just terrible. So that's all I can say.
It's horrible.
As a Halloween story, spooky, scary, but also justice seems to be served here.
It looks like it.
Yes. So as we continue to watch the recess in the Young Thug case, apparently the state and defense have to agree to go forward. There's some issues here, and I'm just apparently Adrian Love is putting some things on the record that people are going crazy about. So we just wait. Remember what Doug Weinstein told us the other day. If there is an offer made, even if you can't come to an agreement on the sentence, you have to bring that offer to the client, no matter what you as a lawyer think about it, what you as a lawyer may want. You have to bring the offer to the client, and the client then has a right to say yes or no, or is there something else we can do? What is it? It's not in the lawyer's ability to do that. It's only the client's ability to do that. So, we'll see.
Yeah, and with any negotiation, obviously the stakes are higher when we're talking about somebody's freedom, or in a death penalty case, somebody's life. But it's still a negotiation. You still have coming forward with a position. You evaluate that. You counter that position. You try to get what you can. Maybe you ask for a little more than you really think you need because it gives you something to throw away. So it's negotiation at the highest, most important level.
Right, and remember, this all started with the judge saying, "Do you want a mistrial?" Okay, so they'd be sitting in jail for another year because it wasn't with prejudice; it was without prejudice, and that's another year of time. You have to think about that. It's not like the trial would start next week again. And so when the fact that Thug's family is in court, Young Thug's family is in court, it's a serious matter. It's a serious matter. That would leave 2 if he does plea. That would leave 2 if he does plea. So.
Yeah, and that would be interesting. The 2 that would remain, again, if Young Thug, Mr. Williams, takes a deal that doesn't require him to testify, I don't know. It seems to me that the holes in the prosecution's case keeps getting bigger and bigger as each of these defendants come to a deal without agreeing to testify.
Okay, so while we watch that, and I see we have comments from everyone. Yes, thank you. Please, yes, happy Halloween. And I know most of our viewers are watching right now, Young Thug.
Yes.
But let's talk about another case that's in New York City, Michael. And that's the case that you actually have press credentials for. You will be covering for Justice Search TV.
Yep, and I will not be wearing this. But I was amazed. First of all, this is the Daniel Penny case, of course, in the death of Jordan Neely, the homeless street performer individual. Happened on the F train in New York, May 1st, 2023. This gentleman was apparently being disruptive. Mr. Penny, the defendant, decided that he would be helping others on the train to subdue this guy, put him in a chokehold. 3 minutes later, he didn't die at the scene, but they couldn't ultimately revive him. He died as a result, and so his death was blamed on asphyxiation as a result of the choking by Mr. Penny. So when we talked about this last, just a couple of days ago, I said, how are they going to get a jury so quickly? Because they had all of these issues with, trying to find people who actually rode the subway. Be nice, because again, jury of your peers. Mr. Penny is a regular subway rider, then somebody in the jury should be a regular subway rider. Well, they got a jury. They impaneled the jury yesterday, and they're going to have opening statements tomorrow.
Right. And most of the people on the jury ride the subway.
Yeah, I was looking at the whole list here. Do you have any favorites you want to look at here? I was just looking at all 12.
Before we went to the list, I'd just like to point out that the attorney that's prosecuting it, assistant district attorney who's head of it, is Joshua Steinglass. Now, why does that name ring a bell? Because he was the ADA who prosecuted the Trump 34 misdemeanor felony conviction.
Oh, that's right.
So I thought that maybe we should note that, and he notes to the jury, as you're talking to him in New York, attorneys can talk to juries, that they don't need to prove intent. Mr. Penny is charged with a manslaughter, which is mere recklessness, or criminally negligent homicide, which is negligence. You don't have to prove that he intended to kill anybody. And negligence, us defense attorneys hate that because that's just like a civil case. I mean, if somebody's negligent or not in what they do, and you get civil damages, but that's the law in New York City. Yeah. So I don't have any favors, so I'll let you go.
Yeah, I just noticed the judges back on the bench and they're chatting in the YSL case. I'm not quite sure what they're chatting about. Let me sneak a peek here.
Yeah, I wish every court would allow questions. It's very hard to pick a jury when you know even your questionnaire that you would give sometimes.
Sir, can you swear in Mr. Williams?
Yep, Jeffrey Williams.
Being sworn in.
This is, I don't have the feed dialed in here, obviously.
So why don't we see what's happening with that? Let's talk about being a live show.
Jeffrey Williams, Jeffrey Williams.
Good afternoon, Mr. Williams.
That's the judge.
Are you the same Jeffrey Williams indicted in case number? Your Honor. Yes, ma'am. Actually, have we all signed the indictment, or are we going to do that afterwards? Because I don't have a copy of it.
I don't Adrian Love again.
I believe that we have. Okay, probably be a good idea to do that.
Have a copy. You don't? Okay.
Where's the one we were using yesterday? We'll do that in just a minute. You can go ahead with the colloquy. And Your Honor, we don't have the waiver form as well. I believe that the court had one.
Right here.
I've got blanks. Y'all filled one out, right?
We have it.
So as usual, it's moving smoothly, smooth as glass.
It's interesting that Adrian Love is involved in this one, right?
Mr. Williams, are you the same Jeffrey Williams indicted in case number 22SC183572?
Yes.
Okay. And are you also known as Young Thug?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you?
33.
And how far have you gone in school?
9.
Say that one more time.
9.
Okay. Are you able to read, write, and understand the English language?
Yes.
All right. Do you understand that you are charged with the following offenses? Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, participation in criminal street gang activity, the leadership charge, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, 3 counts, possession of a firearm during the commission of a felony, and possession of a machine gun. Do you understand that?
Yes.
All right. And do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you will continue to receive a jury trial?
Yes.
All right. And have you received this waiver of rights form that I hold in my hand from your attorney and reviewed it with your attorney?
Yes.
All right. And is this your signature on the bottom of this form?
Yes.
Have you had enough time to speak with your attorneys, Mr. Steele and Mr. Adams, about all of the facts and circumstances known to you regarding the charges in indictment 22SC183572, including any potential defenses?
Yes.
Do you need additional time to discuss this case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Mr. Steele and Mr. Adams, do you on behalf of Mr. Williams waive a formal reading of this indictment?
Yes, Your Honor. You do.
And do you, Mr. Williams, waive any and all defects in this indictment, including any with respect to your name?
Yes.
Have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorneys know of any outstanding warrants related to these charges?
Any what?
Outstanding warrants related to any of the charges in the indictment?
No, no. I don't believe so either, Your Honor.
Okay. And I'm unaware of any as well, Your Honor.
I am as well.
Thank you. Have your attorneys advised you of the minimum and maximum sentence for each of the crimes that you are charged with?
Yes.
And each of the charges that you are pleading guilty to?
Yes.
Your Honor, with respect to the charges that Mr. Williams faces, count 1 carries a minimum charge of 5 years and a maximum charge of 20 years in prison, or up to a $25,000 fine, or both.
Isn't it a $15,000 fine, because wasn't it the version of the statute in effect at the time, or was that the same for RICO? Was RICO 25?
Yes, RICO.
Okay. All right, thank you.
You're welcome. Count 56 carries a minimum sentence of 5 years in prison, a maximum of 20 years in prison, consecutive to any other sentence, with a fine of $10,000 to $15,000, or both.
Okay.
Count 57 carries a minimum sentence of 5 years in prison and a maximum sentence of 20 years in prison. Count 58 carries a minimum sentence of 1 and a maximum sentence of 10 years in prison. Count 59 carries a sentence range of 5 to 30 years in prison. Count 60 carries a sentence
Hang on,
range.
slow down just a second. All right, and that's for the amount of that drug that was found on 59, 5 to 30?
That's as a result of the charge itself, I believe, district with intent to distribute.
I think that 59, Your Honor, is simple possession of cocaine. I have to look at the indictment to be
I think
sure.
that's 60.
Okay.
Let me look.
And Your Honor,
59 is codeine and
Yes.
60 is cocaine.
Yes.
So,
Your Honor, it is with the intent to distribute. So my reading of the statute is that it carries the range of 5 to 30.
okay.
And Your Honor, also, as I have the indictment in my hand from Ms. Roster, may I pass it to counsel for Mr. Williams?
Yes.
Thank you. Your Honor, with the court's permission, I'll permit time
Go ahead.
for them to. Okay. Count 60 carries a range of 1 to 5 years in prison. Count 61 carries a mandatory 5 years consecutive to the underlying felony. Count 62 carries a sentence of 10 years consecutive, for a total maximum exposure of 120 years in prison. Were you aware of that, Mr. Williams?
Yes.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or the Board of Pardons and Paroles, and that if you are sentenced to confinement in the Georgia Department of Corrections, no one can guarantee parole?
Well,
Yes, you can say that.
Oh, yes, ma'am.
Parole.
Your Honor, may I allow Mr. Williams time to finish signing the indictment?
Okay.
Interesting that Adrian Love, the prosecutor, is back on this because it's the big deal, right?
Front and center. Yep.
Front and center.
Your Honor, with permission, may I approach with a member of Mr. Williams' team?
You may.
Thank you.
Okay, so we've heard the numbers. Impressive number of potential years, up to 120. Some of them were designed to be consecutive, not concurrent. A couple of possession with intent to distribute, some firearms issues, and obviously the RICO at the top of the list. So, but there's been no discussion as to which ones are being pled to.
Right. So
and
we're going to have to.
Which ones are being no-load. So
you have to keep listening. We'll have to keep listening and seeing. And also, the judge, will the judge let him go home with time served on whatever he gets?
Yeah, I'm sure of that. I mean, otherwise, why would they?
Right. That's what I think. I think that has to be in there, or soon to be. His family is in there today, right?
Yeah.
I mean, woof. Because otherwise, I could say woof.
So again, will he choke down one of these felonies to do that? It sounds like he will.
Yeah, that's what it sounds like. Color me surprised. Color me pumpkin.
Yeah, I
color this Halloween.
What a squash. Yeah. No, I'm not as surprised as you because when you dangle freedom out there.
Well, let's see.
Sometimes it ain't that bad.
Are they still in court? Can we go back?
They're back now. They just backed out again.
Okay, let's see if we can get it back up again. Let's see what's happening.
Mr. Williams, do you understand that this is a non-negotiated plea of guilty, and that since your guilty plea is a blind plea or a non-negotiated plea, the state is making a recommendation of sentencing to the court, notwithstanding the fact that this is a blind plea? You understand that, Mr. Williams? Okay. And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation, subject to the special requirements of 1615 the gang statute.
Wow.
All right, and do you want to break down for me what your recommended sentence on each count is?
Yes, Your Honor. The state is recommending on count 1, 5 years to serve. Count 56, 20 years to serve consecutively to count 1. Count 57, 5 years of probation to serve consecutively to count 56. Count 58, 10 years of probation to serve concurrently with count 57. Count 59, 5 years of probation to serve concurrently with count 57 and 58. Count 60, 5 years of probation concurrent with count 57, 58, and 59. Count 61, 5 years of probation consecutive to count 57. And count 62, 10 years of probation consecutive to count 61.
All right, thank you.
Mr. Williams, did you discuss the state's previous offer with your attorneys?
Yes.
Okay.
All right, and so we're all clear that we're talking about the same thing. Can you put what the state's previous offer was on the record for me, please?
I can, Your Honor.
Thank you.
The state's previous offer was a total of 43 years with 20 years, 5 years to serve on count 56, commuted to time served, followed by 15 years on probation. On count 58, the sentence was 10 years to serve in the Georgia Department of Corrections, consecutive to count 56. Count 59 was 3 years to serve in the Georgia Department of Corrections, consecutive to counts 56 and 58. Count 60 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, and 59. Count 61 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, 59, and 60.
Was that the entirety of what the sentence was?
No, Your Honor,
I mean, I know
still
there were
reading.
special conditions, so y'all were on null cross, what, 1
Yeah.
and 62?
Yes, as part of the recommended sentence, in exchange for the defendant agreeing to the special conditions that we asked the court to impose, the state was willing to null pros count 1, count 57, and count 62.
Okay, and then all of that consecutive to the probation, that was gonna be what we call backloaded, and what were y'all proposing with regard to that, since it was a total of the probated sentence?
The total sentence was 43 years to serve, with the first 5 years in prison commuted to time served, followed by 15 years on probation, followed by 23 years in prison, which would have been served in confinement, except that if defendant had complied with the special conditions of probation imposed as part of this sentence, the backloaded portion of defendant's sentence would have been commuted. However, should defendant had violated any special condition of probation within the first 15 years of his sentence, his probated sentence would have immediately been revoked, and he would have been required to serve the entire remainder of his sentence confined to the Georgia Department of Corrections.
All right, so as long as he had successfully completed his 15 years of probation, the 23 years that was gonna follow was gonna be commuted to time served, as long as his probation was successful, is that right?
Yes, Your Honor,
Okay.
and the special, would the court like for us to?
No, I was really more interested in the length of sentence and what y'all had, I mean, I know you didn't reach agreement, but yeah, that's what the last offer had been, with, of course, a bunch of special conditions, which I guess is where the hang-up was, I don't know.
Right, defendant did not want to agree to the special conditions.
All right, so basically your understanding too, Mr.
Yes, Your Honor,
Steele
it would
and
have
Mr.
been-
Adams.
Yes, Your Honor, Mr. Williams would have been released today for 15 years on probation. If he successfully completes that probation, then he would not have to go to custody. If he did not, he'd face probation revocation, as well as 23 years, as the court said, backloaded in the Georgia prison system. But we could not come to terms on all the conditions that the district attorney was insisting.
Okay, all right, thank you, go ahead, Ms. Lloyd.
So basically, it's time served. He would have been released today, but
And Mr. Williams, were you aware of that previous offer, as well as all of the requirements that that offer would have entailed?
Yes.
And had you had enough time to discuss that particular offer with your attorneys?
Yes. The preview?
The previous offer. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment? Do you understand that, Mr. Williams?
Yes.
Do you understand that if you enter into a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
No.
Okay, so you're not on
If you
probation.
were on probation, but if you're not, then it doesn't matter.
Okay. Do you understand that if you are placed on probation of any kind by this court, you cannot violate any criminal laws of any governmental unit or any special conditions of probations without being subject to revocation for the balance of the sentence the court imposes?
Yes, I know.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, and the Department of Corrections or Board of Pardons and Paroles, and that no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that, Mr. Williams?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or if you use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of up to 1 to 15 years in prison?
Yes.
Michael, it seems to
Do
me
you
that
understand that
the
you
parties
waive
must
any
have an
and all
agreement with the
offenses,
judge,
including
or
any
an
mental
indication
health
from the
offenses,
judge
by
when
entering
she's
a
going
plea
to
of
go.
guilty?
Yes.
Do you understand that if you went to trial, you would have the right to, that if you continued at trial, rather, you would continue to have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand all of those things?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury. Do you understand that?
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to continued assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the continued trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proven beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Well, Your Honor, may I interject?
You may.
Your Honor, on count 1, which is the racketeering conspiracy count, Mr. Williams is tendering a plea under nolo contendere. As to count 56, which is participation in a criminal street gang activity as being a leader or supervisor or organizer, Mr. Williams is also tendering a plea to this honorable court as under nolo contendere. The balance of the count, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes, yes, sure. Your Honor, the state asked that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right, I'm going to permit a NOLO plea as to counts 1 and 56.
Nice try, though.
That's right. 1 in 56, that was another
Mr.
one.
Yep, yep.
Our viewers are following this. I'm trying to tweet it as
As
we're going
to
on.
count
Exit.
57, participation in criminal street gang activity, how do you plead?
plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 60, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony, how do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, how do you plead?
No law.
As to count 56, participation in criminal street gang activity under the leadership charge, how do you plead?
No law.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
Guilty.
Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
Are your guilty pleas and your NOLO pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today's date for a felony charge and 12 months from today's date you don't have a misdemeanor charge, but to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Your Honor, also, do
You have
my-
30 days from
I was-
today to file a direct appeal from this guilty plea and until the end of this term of court to file a motion seeking to withdraw the guilty plea, which does not mean it would be granted, but that's the time period, okay?
What's a direct appeal?
Well, you can talk to your attorneys more about it, but it would be up to one of the, like the Court of Appeals, I think is where this one would go. Those just the time periods.
And Your Honor, the state, in addition to the sentence we are asking that the court to impose,
Okay.
we would also be asking the court to require or to forfeit, have defendant forfeit all the property that has been seized and that is currently being held, that was found or recovered or taken from his home after it was searched on May 9th.
Do you have any kind of list of what that property is? I mean, I'm not familiar with what was seized.
And Your Honor, we're not
do.
agreeing.
No,
I mean-
thanks.
I mean, I assume y'all aren't agreeing to anything.
We're not
You
agreeing
would
to that.
present it as a negotiated plea.
We're not, but we do have a list of the
All right.
property
Do you have
items.
it where available right now?
Yes, actually, would the court permit us to send it electronically?
Sure,
Because we
that's
have-
fine. And then,
Sounds
if
like they
that
haven't
is not
discussed that at
posted
all,
condition,
right?
is
I
it
don't
just
think they ever got that
litigated
far.
as like any forfeiture matter?
Yeah,
Yeah, it would be litigated later on,
It's a
yes.
civil separate filing
Okay.
in this court. It's not related to the
All
court.
right.
It's related case, but it's unrelated.
Understood.
And we are sending that to Your Honor
Thank you.
at this time. And as it relates to the conditions of a conviction under 1615-4, Your Honor, we would ask, or as part of the sentence, defendant would be required to adhere to the requirements, the sentencing requirements of the gang statute, which at least in part require that he not associate with any gang members whatsoever. And I can read the rest of that into the record if the court requires, or I can continue with the factual basis.
All right, and let me ask you, because I know that at least while y'all were negotiating, one of the things that I guess was being negotiated was some exception for, I think, somebody that is contractually obligated on his record label. Is that something that the state would still be in agreement to?
No, Your Honor.
Okay. All right, go ahead.
All right. Your Honor, as part of the requirements of 1615-4, Yes.
Michael, what amazes me, though, it sounds like they don't even have this kind of worked out, even though it's a non-negotiated plea. And already we see problems. I'm a young thug. Unless I'm going home today, I'm concerned.
Defendant.
Yeah.
One moment, Your Honor.
And it sounds like the sticking point was this back end.
In addition.
That's right.
To any other penalty provided.
The judge is being
by the
very
code section, all
solicited to the
sentences
prosecutor.
imposed under the code
I'm-
section shall require as a special condition of the sentence that the person sentenced shall not knowingly have. Just a tad, because there's a court reporter taking it down. When we start reading, we read really fast. So go ahead. This code section shall require as a special condition of the sentence that the person sentenced shall not knowingly have contact of any kind or character with any other member or associate of a criminal street gang, shall not participate in any criminal gang activity, and in cases involving a victim, shall not knowingly have contact of any kind or character with any such victim or any member of any such victim's family or household. So that is, and we've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case,
I think I'd be opting out of this data right now if I'm on
been
the
tried and would continue to be tried until the state completed its case in chief. The evidence has shown that the defendant, throughout the time between 2013 to 2022, conspired with both indicted and unindicted co-conspirators to participate in the enterprise known as Young Slime Life, or YSL, through a pattern of racketeering activity. Throughout that time, multiple conspirators, both indicted and unindicted, and including the defendant, have committed overt acts intended to further the enterprise itself. With regard to the defendant, as far back, the evidence has shown, as 2013, the defendant, along with other YSL founding members, Walter Murphy,
What's that?
Are you comfortable with all these conditions? It seems like any that could be violated.
No, there's no way that one involves some of the guys on the record label.
Right. Nobody in the gang.
So obviously Steele's going to address that and hope the judge doesn't impose it.
In that particular
After
act,
you're feeling what we're feeling right now.
the armed robbery of an Archillian Bennett back in 2013. As alleged
Yes,
in the
Mimi,
indictment,
they can take almost anything under the forfeiture statutes.
defendant.
Yeah, I think that's probably the least of their worries, which is why they didn't get to it.
Right.
Committed acts
They're worried about whether he goes home.
YSL that included drug sales, aggravated assault, and murder. They used and furthered, rather, this conspiracy by using social media posts and music to assert the violent nature of and the dominance of Young Slime Life, which is also known as YSL. The defendant is charged with being a leader of the gang YSL, and evidence has been presented by accomplices and co-founders of YSL, Trontavia Stevens and Walter Murphy, and evidence would
We
have
have to
been
see what
presented
Steele
in
does
the
with
words of the defendant
Sorry,
himself,
hey, wait a second. We're
that
not
the
pleading
defendant,
to any of that.
as shown by some of his own social media postings, was the founder, one of the founders of YSL, along with Mr. Stevens and Mr. Murphy. YSL formed, according to the evidence that has come out in this trial, in 2012, 2013, under the former version of
She's
the
going
name
to
of
recite
gang
the evidence
called
that they think has
Rock
come
Group
out.
on
This
Race
can take
on
another year.
Cleveland.
We've seen this before.
The court has heard evidence of the 2014 and 2015 incidents that have involved conflicts between YSL members and IF gang members that included someone shooting the window of Mr. Williams' car and armed individuals rushing outside during shootings at Club Crucial to ensure Mr. Williams' safety, shootings at a place called the Dugout where armed individuals rushed to ensure Mr. Williams' safety, shootings at Mr. Kelvin Watts committed by members of YSL, communication with members of YSL after those incidents, and ultimately the murder of Donovan Thomas at the hands of members of YSL. The evidence has shown and will show that on January 10th of 2015, members of YSL drove a car rented by the defendant, a gray Infiniti, and drove past Mr. Thomas as he stood outside of a barber shop congregating with friends, and unloaded an array of bullets on Mr. Thomas, hitting him, his Chevrolet Tahoe, and two other persons in the process. Mr. Thomas died from those bullets. Phone records show that communication was held between Mr. Williams, Mr. Kelvin Treadwell, Mr. Demise McMullen, corroborating accomplice testimony that has been presented in this courtroom regarding what happened, who committed the murder, and what happened to the guns and the vehicles that were used in the murder. After the murder of Donovan Thomas Jr., the members of YSL responsible for the murder and members of YSL who were not responsible for the murder congregated at Mr. Williams' condominium called the Sky House, and they all made plans and later either drove or flew down to Miami. Prior factual acknowledgments by
I'm
members
suspicious
of
of the timing
YSL
of all this. However,
that
it seems to me there has to be a wink from the judge that he's going to get out pretty soon. But it seems to me, yes, Afton, I agree.
Miami
but
money to lay low.
It is the client's determination. But
as they
unless he's getting out today,
left the city.
If Steele doesn't have some sort of understanding as to what's going to happen, he would never jump into this thing.
Right.
There's just no way.
Right. I mean, how can you not? I mean, he can't even talk to his record label. Are you going to try to take his proceeds from the record label? Is that why the record officials were there yesterday? His record label officials were in court.
Shootings at Mr. Darren Mills' mother's home, and I said Mr. Rashawn Bennett's mother's home. Shootings unrelated to the conflict with members.
When will the Fonnie Willis press conference be?
Well, next year, if we don't get through this and the judge gets a sentence, and I assume the judge is going to sentence today.
I would think, yeah. I hope I get to stay for it.
You may go to a Halloween party and come back at midnight, and I'm still here.
Still going.
With the intent to disrupt and cause harm and to shoot up Lil Wayne's tour bus. Lil Wayne was another artist with whom
Oh my God.
was having conflict.
Stephen Parrish says, should we tune in tomorrow to hear the end of Love's discussion?
At that time,
God.
I mean, this is a big deal. This is the chance they have to say, look, he did all this, and then Steele's going to get up and say, we're not pleading to that. We're pleading to all this. We've heard this before.
All very interesting, but no.
Yeah, right. There has to be some wink from the judge to be able to, or else he would never do this.
No.
The client wouldn't do this. The client's not going to take that.
No.
About the persons who were threatening him with the lawsuit, and as a result, he had to rename his
Well, remember, if the judge said this was a mistrial without prejudice, they'd have to be in jail for another year, 2 to 3 years. So,
Yeah, and we talked about that. That a factor was what gets me out of jail.
right, get out of jail free. Now it's like a flea market, only with very
With a
serious-
heavy chain on your leg.
Right.
From Mr. Wimpy, free. And members.
Mimi says, I'm glad you guys are talking so not to hear her. I think I'm talking so I don't have to hear her either, because all she's doing is repeating the indictment and the overt act she believes she proved, which we all
She
want.
did not.
Prove. And so, this is her way to say, hey, we're successful. And then Fonnie Willis is going to say, hey, we're successful.
Mhm.
Hey, vote for me. You see what I did?
Yep.
I'm sure Brian Steele's not feeling so good either. He'll feel good if his client gets to go home today or tomorrow.
The music, Your Honor, contained.
Oh God, the music.
Here we go. The music and the lyrics. Let's just talk about this, because now she's going through the music and the lyrics. We still have Shannon Stillwell left, and we still have Doug Weinstein, his client, Diamante.
Kendrick, yeah.
I read my life for real.
Well, she's going to read the lyrics.
Now she's going to read the lyrics. I can't even. If I were the judge, wouldn't you say, all right, we've heard all that, we understand that, but this, I'd want to hear from Mr. Steele about what exactly are the overt acts he's pleading guilty to on a factual basis.
I think she's leaving. Oh no, she's just getting some papers. And then, of course, you're going to have to deal with Steele's contempt. Remember, he still has to deal with that.
Of a song wherein Mr. Williams sang or rapped the lyrics. Hey, slime shit.
I wish I had learned the lyrics by now. They've been repeated so many times.
I'm in the VIP. I got the pistol on my hip. Fuck the police. You praying that you live. I'm praying that I hit. It's that slime shit. 100 rounds in a Tahoe. I'm prepared.
She's performing as she has.
Yep.
For all these ends acting monkey. This is that slime shit. This is that mob shit. Fuck the judge. YSL. This that mob life.
Wait a minute. Is there it? Can I? I guess it doesn't.
I don't think it's gonna work. I mean, could I scare her with my I mean, y'all know I came with wearing a I didn't expect this Halloween, this show on Halloween to be this show, Michael Bryant.
Well,
frankly.
she is masquerading as a prosecutor.
I mean, I came with To Be My Dog's Time. This is very serious stuff. You've got people just talk about murder, and then if Steele gets up and said, "No, this is not what we're pleading for, Your Honor. We're pleading for this, this, and this," it's the same thing trying to get the forfeiture in that apparently was never
another
discussed.
song, Defendant Williams raps.
Here's another song.
Like
And not to, not to want. I don't want
Giggle,
them to
YSL
be able to have a
won't
NOLO
pick his
plea.
ass off
I don't
from the
want that.
balcony.
Yeah, because she said right, and then
knows
try to get in the fact that he said he was only doing a NOLO
I'm
plea.
going to
NOLO
F for
contender
the
is when you
cash,
don't
then she
contend.
getting robbed by
you know,
Tick. A reference to
you don't plead
Trontavious
guilty.
Stevens.
More
All I ever
serious
wanted was the
counts.
money. Put your hands in the air if you dare. F and N, put him in a wheelchair.
Ugh. So they try to get that under, even with this. So that's why I'm not comfortable.
And
I know
even later
you got to
on,
do what's best for your
Mr.
client, and the client has
Williams,
to
and
do
I
what's
believe
best
that
for
this
you.
was
I'm not
in
comfortable when she's trying to
2019,
get
made
the
a post
forfeiture underneath and
to
doing the lyrics
YFN
again and try to
Lucci
say
or
this is
Rayshawn Bennett.
not a
If it-
it's not a
If
guilty
I
plea.
didn't like
it's a
what you
NOLO
do for
plea,
your
or
mother
it's a
and
guilty
kids,
plea,
I
it's
would
a
have
NOLO
been
plea.
killed you.
I don't know
And in
how
yet another
after
song
how
entitled
Yak
Anybody,
Gotti
Defendant
and
Williams
Shannon Stillwell,
stated,
what's going on
I
now?
never
How this
killed
affects me. I
anybody,
really don't.
but I
have
got
to think
something to
about it
do with
overnight.
that body. I got the streets on my back, carry it like I'm moving a body. I told them to shoot 100 rounds like he trying to movie the body.
ready for war like I'm Russia. I get all types of cash. I'm a general.
Michael, I think you should take your judge's, barrister's wig and go to a Halloween party. I'll just sit here. I will give, I came prepared for Halloween.
Do you have snacks?
Candy. Yeah, be prepared for it.
Yeah, I'll be listening on
As
the road.
Mr. Williams' prominence
We'll figure out some time tomorrow to talk about
music
this and maybe
industry
get Doug
rose,
to join in,
Yeah,
depending on
his
what time.
ascension
Yeah, maybe we can get
within
Doug in. It'd have to be in the
his
morning,
leadership
though,
in the gang
because I'm gonna
YSL became more apparent.
We'll just, we'll
as
talk more
he
about it.
rapped and
if
talked
this ever
about the
But
crimes
happens.
I'll
that
stay on with our
YSL
viewers and let the stream.
co-conspirators and
Okay.
members committed,
Sorry to bail, but for
and
me,
how he
it's
got away with
court is
robberies.
adjourned.
Snacks, yes, we have. I actually went Halloween because we thought it was going to be a fun Halloween shot. Well, not fun. It's never fun talking about crime, but at least it wasn't as serious.
With respect to the Donovan Thomas murder,
Except for the, as you know, we started the show with the
court has
Supreme
heard
Court of Missouri
evidence
saying that
through phone
sex
records that
offenders don't
within
have to put
6
out signs
minutes
saying
of the
no
shooting
candy.
of Donovan Thomas Jr., a phone call was made from Demise McMullen's cell phone to defendant Williams' phone, and then immediately after that
So
call,
all
Mr.
those of
Williams
you watching,
calls
how long do
his
you think
sister
that she's
Dora
going to go
Greer,
on? How long
and
do you
then
think this is
calls
going to take?
Kelvin Treadwell. There's then a series of calls between Dora Greer and Treadwell, and then Treadwell calls Demise McMullen or Nard. All of those calls happen within 15 minutes
Karen
of the
Dusty
911
loves sees
call.
a
And as I
Grammy
stated
in her
before, the court
future.
has
Oh, I love
heard
that. That's
accomplice prior inconsistent statements
45 minutes,
about
you
who
think?
committed
Well,
the
hasn't she
murder
been going
himself
on for how long has
and
she
what
been going on
happened
for?
afterwards.
I mean, we never got to talk about the Daniel Penny case, which we are going to be covering in court from Justice Served TV when this came up.
The conflict between YSL and members of If Gang continued into 2019, wherein Mr. Williams raps the lyrics that I referred to earlier. In May 2019, a YSL member shot multiple times at a vehicle owned by Rayshawn Bennett, a black and red Mercedes-Benz G-Wagon.
Okay, I'm into the Twizzler stage.
At the time was being driven by a Milton Howard Jr. It was after that incident, later in August 2019, that defendant Williams posted on his page the language YFN, if I ain't like what you do for your mother and kids, I would have been killed you. The post was then deleted from his account. Through text messages of a co-conspirator, Marquavius
Pumpkin
Huey,
orange, also.
there was
Everything was orange
communication
today,
between
Marco.
Mr. Huey and Mr. Williams, both in January and in September of 2020. On January 19th, 2020,
think about
Mr.
it. Connie
Williams
Lewis
sent
uses
a
this
flyer
as
to
he's gonna win
Marquavius
Tuesday,
Huey
she's
with
gonna
the
say, "See,
performance
I'm a big
location,
guy. I got him. I
Rayshawn
got him."
Bennett,
And
or
that's,
YFN Lucci.
that's what
And
politics
when
is
he
about.
sent that,
No
he
one's
sent
going to
it
look
with the
back and say,
message,
we spent a year
handle
listening
that
to this
tonight,
trial. We didn't think there was any
slat,
evidence. But
SLATT.
you've all of a sudden
Mr. Huey responded, slat, SLATT.
have this
On September
unexpectedly on
2nd,
Halloween.
2020, Mr. Huey sent a flyer to Mr.
And
Williams
this is not how plea
with
deals
another
normally go.
performance location of
Repeating the
YFN
whole,
Lucci.
repeating
And
every
Mr.
single overt
Williams
act in
responded,
the
slatty,
36 pages.
that is SLATTY, handle, and stay very low. Mr. Huey responded, slat, and for show, FASHO. I've been out the way and appreciate you for everything, my brother. Never about money with me. I'm built on loyalty. Mr. Williams responded, slat, handle that. I got you. Through text messages and on a separate occasion, Mr. Huey said and conveyed to
Slat,
Mr.
slime
Williams
life
that he
all
will
the
sit
time.
down for any one of them. And I believe that to be a reference of going to jail. When Mr. Bennett was not
You know,
killed
I had
in
an
2022,
post tweet ready to go. Judge sentences YSL breaking. It may be by the time it's breaking, it may be tomorrow.
Dominate the rift with Opera GX. Install any
great.
official LOL
Ads
esports
that are
mod from
played by AI. It's really kind of funny. The other one was
Garlington to get
was
permission
but
from
these
Mr. Williams.
These are played by
Demikian
AI. We have no
Garlington
control of that.
was also involved in the back and forth shootings back in 2015.
But it was
On
kind of
February
comic
9th,
relief, wasn't it?
2022, Rashawn Bennett was stabbed by Jaden Myrick at the Fulton County Jail. And after that stabbing, Mr. Myrick reached out multiple times to
Back
Mr.
to the
Adams
Twizzler.
for some type of compensation for the stabbing. Mr. Adams reached out to Mr. Garlington about the payment for the completion. On February the 22nd, 2022, YSL co-conspirator and co-indictee Christian Eppinger called YSL co-conspirator Antonio Sumlin to get permission to finish what Mr. Myrick could not complete. That is the
I'm trigger-treating my own stuff that I bought for you.
Mr.
I'm eating
Eppinger
this, and I
asked
don't
for
usually
payment
eat
for a
candy.
lawyer. However, these calls were intercepted
I'm figuring I'm
and
eating
Mr.
sugar for
Bennett
the
was
6-hour
relocated.
more that this is going to take.
In March 2022, information about the stabbing made the news, and shortly thereafter, a series of violent offenses occurred. On March 11, 2022, YSL associates Christian McMiller and Darius Ford were gunned down. Mr. McMiller is a childhood friend of Mr. Williams. Mr. Ford was also a friend of Mr. Williams. On March 12th, the day after, there was a shootout near the Cleveland Avenue area. A shooting by a YSL associate, Stephen Harris, in YFN territory occurred, and a YFN member was shot in the head. March 11th through March 14th, there were a number of social media posts going back and forth between members of YSL and YFN. One of them was a post by Shannon Stillwells. We ain't the only ones who ain't going to be crying, that's going to be crying. After a posting was made by Mr. Watts picturing him, Mr. Shamel Drinks, and Mr. Jasper Walters,
I mean, you can see that as you're watching
14th,
YSL, Jeffrey Williams,
after YSL
Brian Steele. They're starting to get tired of just standing there because remember, they have to go forward and they have to
gunned down
make
as he drove
statements
away from the
also,
gas station and waited at a red light.
before the judge sentences, and that's to maybe refute
Later, Mr.
some of the things she
Stillwell,
said.
Mr. Nicholas,
She
Mr.
considers
Garlington, and
part of the plea, which
Farley
they
were all
don't.
charged with the murder. That is one of the acts that we are still would anticipate the court seeing the evidence of during the course of this trial. After grand jury warrants were issued after this indictment for Mr. Williams and 27 other co-conspirators, following searches of phones, wiretaps, and other information that led police to understand the role that Mr. Williams played in the YSL street gang and enterprise. Mr. Williams' home, he was arrested at his home and a search warrant was executed inside his home. While at his home, a sale amounts of illegal narcotics, including those that he is charged with in this indictment, was found.
No, actually, he pled guilty to different counts, but I expect
was the
girl Ryan that sorry, I had to lean in there. That he, what's going to happen is Steele's going to get up and say, no, we nolo contendere to count 1 and count 56. Just nolo contendere, not that we agree to that, although we're going to plead guilty for the purposes of you've shown evidence, and that we're pleading guilty to some other counts, and this is what we're pleading guilty to. This to me is like a press conference to say, hey, this is what, this is what they're pleading guilty to, even if it's not what they're pleading guilty to, kind of the way Bruce Harvey said the other day, kind of what Bruce Harvey said the other day. So it's painful. I know it's painful. I think we had a little glitch. There we go.
The defendant has been charged in this indictment.
What bothers me though is the judge not standing in and saying, "Hey, look, we understand
The
that.
gun
I
has
got what
switched.
he's pleading guilty.
The
I want to hear
narcotics
from
included
him."
marijuana, codeine, and cocaine. And inside the home were also other guns besides the guns with the switch. The items were seized, and again, Mr. Williams was subsequently arrested, along with other YSL members at Mr. Williams' home. Your Honor, that is the evidence that I believe has been shown throughout the course of this trial, and that the state would continue to show. There are several messages between Mr. Huey and Mr. Williams inside the cell phone, that one of the cell phones that were recovered from Mr. Huey, besides the messages about tells
She
Mr.
can't
Williams he has a
use
new number.
Afton. She can't use anything in this plea
Mr.
against
Williams,
other people unless
hey, my brother, I'm
Williams
fucked up. You ain't got nobody I can
testifies.
pull up on and have something in my
Williams
pocket.
would have to come in and
Mr.
testify
Williams
against them.
responds, slat. Let me call BEO. Mr. Huey
And
responding, slat. I need you, my
one of
brother.
the things that's impressed me this
Mr. Huey said,
all these
asking
pleas
whether or not the
is
lawyer
that
was going to
the
go and talk
state
to
could
another
not get
YSL
anyone to
associate,
say,
asking
we're going
Mr.
to come in
Williams
and
to send him some
testify.
money
They
to pay
couldn't
his
flip
lawyer off.
anyone.
Mr.
They
Williams
couldn't
asking
make
Mr.
anyone
Huey,
become
who
a
had
snitch.
been accused
And they didn't
of
have
armed
such
robbery.
good luck at the
more than
ones they
once.
did previously.
Mr. Huey
I refer
responded
you to
with
little
the number.
Moody.
Mr. Williams responded, slat. After Mr. Williams stole a star ring from one of the victims in the indictment, he asked Mr. Williams, do you have a star ring? Mr. Williams.
I think even the feed is saying, "Hey,
said,
hurry up."
yes. Mr. Huey said, slat, you can't cash at me $500 so I can make a payment to my lawyer. Mr. Williams responded, slat. Mr. Huey sent him his phone number. Mr. Williams assured him through his responses, slat, that he would take care of them. Throughout
you see
Mr.
how
Huey's
uncomfortable
phone,
even just standing there.
see
This
messages
is
of this nature between Mr.
Steele and YSL
and Mr.
and
Williams.
Adams. Just they've been standing there
The
for.
court again will
We
hear
started
that
our show at
as
4
this
o'clock
trial
today,
continues.
right? And this
The
started
recommendation
about, almost an
that
hour ago
the state
now.
previously made prior
Wow,
to
that
us reaching this point was
unexpectedly
made with the hope
and
that
this has been going on
Williams
for this whole
would
time now. So we never really got to talk to you much about
conditions of
the Penny
probation
case,
that
which
we
I
asked
expect that we
him to
will
adhere to, and that he
with,
would
but,
take
we all know that
ownership
this
and
is the
responsibility
trial that's
for being
soon
the
going.
leader
We
of
still have the Weinstein's
YSL.
coming out here. Jack Gotti.
Given that those
Yes, I am talking
negotiations
over
have broken
Ms.
down,
Love.
we are asking that the court sentence Mr. Williams as we have asked earlier. And prior to the court imposing a sentence, we would ask that Ms. Shawana Edmonds, who is
These are
the
very
mother of
serious
Mr.
charges,
Thomas,
Joe Ryan.
be
Yes,
allowed
there's
an
been,
opportunity
these
to make an
murders
impact
alleged here.
statement.
And
that is
somebody
all
has
that we
pleaded
have unless
guilty
the
to
court
one of
has
them already,
questions.
right? So
Okay,
it's
well,
very
given
serious.
that Mr. Williams is not charged with the murder of Mr. Thomas, I don't think that is applicable here.
I checked on that, Your Honor, with respect to count one. As a co-conspirator, Mr. Williams is responsible for all of the acts of the other co-conspirators, the overt acts. The overt act of the murder of Donovan Thomas is one of those acts.
I know, and this trial is not complete, and so y'all have not yet proven that. Not to mention that you dismissed the murder charge against one of the co-defendants who already pled. So,
well, that's pretty good.
Not for that case, Your Honor. That was a different. That was Mr. Drinks.
okay.
We have not dismissed any.
All right. Well, if there is a conviction on the RICO or murder count following the close of this trial, that would be the appropriate time for the victim impact statement to be made. All right, Mr. Steele or Mr. Adams, does the defense want to put anything on the record? Obviously, you need to make a recommendation.
Yes, Your Honor.
Go ahead.
Many of the statements made by the prosecutor, we vehemently disagree with. The prosecutor misstated many pieces of evidence and then took liberty that that is the state's theory. Mr. Williams has tendered a nolo contendere plea to the RICO conspiracy count. And in that count, there are several overt acts. And the first one, Your Honor, deals with a traffic stop. It's on September 9th of 2013. And I won't go through every one because it might take a long time, but just for completeness for this, the court knows, Mr. Williams is driving a car. There is a dash cam video of the stop. The officer who testified at the trial 11 years later. The case was, a gun was found under the passenger seat. Mr. Williams is not tied to the gun. He's not convicted of that. And the dash cam video that the officer said would have picked up sound as well as definitely video was never turned over to us, supposedly lost, could not explain the loss. The armed robbery in another overt act of Mr. Dodson, D-O-D-S-O-N, has the following information. The state only, because we haven't called witnesses yet. So the state put up a man who said nothing except, I don't recall. And then they put in his prior recorded jail calls. That man was taken, his name is Mr. Bean, B-E-A-N. He was taken to Grady Hospital and he was spoken with by a detective. The state vehemently accused me of lying to the jury, that the man never went, Mr. Bean was never taken to Grady Hospital, and that somehow I planted on him to say something on a recording where he said, the reason I implicated Jeffrey Williams is because the police told me that it would be easier for me. Then I had to go through the CAD reports and show that Mr. Bean was in fact taken to Grady Hospital, and Mr. Bean on recording told Detective Quinn, who of course told the truth. Yes, when I spoke to the detective previously, I did lie. Then what the state doesn't tell.
Oh, I want to hear what the state said. Okay, all right. And no, the acrobat, I guess you're more important. History
He
exam.
pled guilty. His name is Fred Prethrow, P-R-E-T-H-O. And Mr. Prethrow is in the Georgia State Prison System, easy to find. Mr. Prethrow was in Grady Hospital also, unfortunately suffering from a gunshot wound. And you can hear the medical equipment behind him. And Detective Williams came in and was recording the whole conversation and said how many people were in the car. And Mr. Prethrow names the people. Adrian Bean, who's the gentleman I just said, himself, and Walter Murphy. Are you sure they weren't a fourth person in the car? No, the three of us. The state doesn't call that person. The state does call Detective Williams. So I wanted to ask and inquire on that. The state, to obstruct, if that's obstruction, asked the predecessor court to prohibit me from getting into the fact of any conversation that would have impeached another witness. It's fine. Fred Prethrow's on my witness list as well as the detective, and I have the recordings. In addition to that, Walter Murphy gave a statement while in the hospital, and his statement is very interesting. It's two different police reports, signed the same date, which is September 11th of 2013, and on the first 7 lines of the police report, they're identical. Then all of a sudden, when it gets to on the right-hand police report,
this is, by the way, not how
Mr.
pleas
Murphy
usually go. They usually go.
Stated that there were 3 people, I believe, I have to go back, in the vehicle.
Over
on the other
all
police
the
report,
facts that
it
obviously
states
caused this
Mr. Murphy stated there were 4 people. There's no reason that they should be different. They're both signed the same. The state doesn't call that officer at all. I tried to ask Mr. Murphy about it. The state objects, and the predecessor judge sustained the objection. Mr. Williams was not involved in the Mr. Dotson. Miss Bennett, that was Mother's Day, May 12, 2013. She reports allegedly an armed robbery. The detective who testified here and investigated stated he never took out arrest warrants from Mr. Williams. And he wrote in his police report, Miss Bennett is not truthful. That is the case that the state is talking about. The state then, there was Brady evidence that they don't turn over, and we find out about it in court after they arrest Miss Bennett because they say she's not cooperating, and it comes out that she told the prosecution over and over again that this did not happen the way that she reported it, and she doesn't remember. As to Donovan Thomas, and Mr. Williams has nothing but empathy, sympathy, and sorrow. They were friends. It is a lie. What the prosecution put before this jury is a lie. What happened here is the prosecution comes up with a theory. because they need a motive, they think. I know you don't need a motive in reality to prove a murder case or any other case, but they wanted a motive. So they made it where Mr. Williams and a gentleman named Rich Homie Kwan, his name is Mr. Lamar, he's a performer, and Mr. Williams and Mr. Lamar were close. There are public documents, recordings, Mr. Lamar being interviewed almost every year, and then he talks about his time with this band or group called Rich Gang. And he says every year up to this past year, he, God forbid, died. We can't call him as a witness, how close he is to Mr. Williams. The state, though, made it in this case, or tried to make it, that Mr. Williams and Mr. Rich Homie Kwan are enemies because Rich Homie Kwan will not sign with a record label that has nothing to do with Mr. Williams. Mr. Williams doesn't sign to that record label. That record label is owned by a gentleman named Brian Williams, also goes by Birdman, wildly successful. He started Drake's career. He started Mr. Dwayne Carter, performer known as Lil Wayne's career. He started Nicki Minaj's career, just fabulous, powerful person, well-respected in the industry. But the state wants it to be that Donovan Thomas interceded and would not let Rich Homie Kwan sign to Mr. Brian Birdman Williams. And that is the reason that Jeffrey Williams had a feud and killed Donovan Thomas. Your Honor, what the evidence would really show if we kept going to trial, and I could tell you that Mr. Adams and I never thought we'd be in front of this honorable court. We always thought it would go all the way through trial. Was the state is saying that Rich Homie Kwan and Jeffrey Williams don't speak since the fall, and they have a bad relationship, the fall of 2014. We would have shown, and we served on the state, December 15, 2014, Jeffrey Williams in a private plane with Mr. Lamar or Rich Homie Kwan, and they are high-fiving and laughing with each other. That is on audio video. There's a man who the state hasn't called yet, Mr. Martinez Arnold, also known as Duke. It's on the state's witness list. He's represented by the Honorable Ashley Merchant. He's on that plane as well. He would have identified the item, and he would have testified that Mr. Williams and Mr. Lamar were very close in December 2014. Then on December 29th of 2014, Mr. Williams, Mr. Rich Homie Kwan, Mr. Arnold, others were at Brian Williams' home in Miami, Florida. There was a posting by Mr. Lamar, Rich Homie Kwan, and a picture of Mr. Arnold and Mr. Lamar, and they said, Mr. Lamar says, "This is my number one man, Duke," or something to that effect. We would have put that into evidence. In addition to that, Your Honor, on December 8th, 2 days before Mr. Thomas, God forbid, was killed, Mr. Williams is with Mr. Thomas, as well as Mr. Sledge and Brian Williams in Brian Williams' tour bus outside of a fabulous entertainer, artist, Mr. Clifford Harris, T.I.'s studio. And at that time, they were very close. But you also have the detective with the gang unit, Detective Underwood. I asked her within the last 2 weeks or 3 weeks, did you do any, and she was on the gang
Basically,
the entire
this is
time, including
still
today.
putting in
And
the case
I
that they
asked
would
her, do
put
you have any
in.
evidence about
He's not going to do everything, but
Williams
to show
and Mr.
that
Thomas
the recitation
being
by
close
love
friends?
was a
And she
lie.
said,
And he
yes.
basically
Of course I
called the
did. I said,
recitation
how
a
about in
lie, and the case
January
came
of
out.
2015, close to time of Mr. Thomas's death? She said, yes, they were close friends. Mr. Michael Sprinkle, he's a deputy district attorney in the Fulton County DA's office. He has a recording with Mr. Treadwell. You've heard the name O.G. Bentley. And in that, they're going through the evidence. And Mr. Treadwell, it's important because he has a child, two actually, with Mr. Thomas's sister. So he's family. And Mr. Sprinkle states this is 2018. This is after the rental car. This is after all of the interviews of Mr. Copeland. This is after the interviews of Mr. Zachary. Mr. Sprinkle's in some of those interviews with Mr. Zachary. Mr. Sprinkle on tape, on recording, states, I do not know why anybody thinks Jeffrey Williams is involved in this killing. He and Donovan Thomas were close friends. It makes no sense to anyone. And Mr. Williams was never arrested, never charged, even in this, as the court just noted, with anything to do with Donovan Thomas's, God forbid, killing. In addition to that, Donovan Thomas
has a place that he used to stay with a group of people on Auburn Avenue. Jeffrey Williams performed and did a music shoot there to try to help other people who are suffering in poverty to get out and to be able to be seen and to broadcast their music. Jeffrey Williams does that for everybody because he comes, Your Honor, from the struggle of total poverty, seeing people killed. He saw his brother die right in front of him, and the law enforcement, I'm not blaming anybody, everybody's on edge, but law enforcement would not get any help for him because there are all these people around. It is just what Mr. Williams has gone through is wrong for everyone. It's not just Mr. Williams, it's that whole community, but he's trying to get people out of poverty and out of that community. I have been with Mr. Williams where we have gone to speak with children together, and he tells them, don't be a rapper. Be like Brian, be a lawyer, keep in school. He tells his children, get your education. His family, his whole being, Your Honor, is trying to break the chains of poverty for others, and it has been spun in this courtroom with false statements and allegations against Mr. Williams at every turn. In addition to that, Your Honor, the state talks about the fact that Mr. Williams takes people to Miami. You would have heard evidence if we went forward. I put all these people on my witness list. Not one person on my witness list has been interviewed by law enforcement or the prosecution. They have investigated this case for 15 years. They haven't interviewed all these people. That Sprinter van that you heard about, that was already booked days before. Going to Miami, Florida, Mr. Williams and Mr. Brian Birdman Williams, they did a video shoot for a music video. If anybody would have gone further with the expert for the state, they would have seen that Mr. Williams' cell phone does not contact any of the co-defendants that are named here in Miami, and Mr. Williams stays at a separate location than any of those persons. He would always take people who can't afford it on airplanes, on buses, on tours, to his concerts. He let everyone go because, Your Honor, they never left that area. He wanted to show people you have an opportunity. The world is big. Mr. Williams gave jobs to everybody who'd want to work. He'd give them jobs and security, and I'm not insulting them. They really weren't their jobs, but they were being mentored, but they were given titles and tried to give them respect and opportunity. But if they did not wish to work, Mr. Williams would not allow them to work with them. This has all been turned on its head by the state. The fact that the state has put in Mr. Williams' lyrics are offensive. Mr. Williams has tens of thousands of recordings. On our witness list, we are bringing in all of his people, his recording artists, his engineers, his managers, his record label, and an expert, the Honorable Dr. Eric Nielsen, to talk about how Mr. Williams creates his music. His music is then changed around and merged. Mr. Williams, some of the lyrics you just heard are not even uttered by Mr. Williams. The state has no idea when these lyrics were made. Some of them were made before the shooting of Donovan Thomas that the state is saying this applies to the Donovan Thomas killing with the Tahoe.
Ooh, they've glitched again. Oh, I see why. We're finding law. Maybe we can find justice in the courtroom. It almost sounds to me that Steele wants to put on a defense case for sentencing.
Mr. Williams, but they don't care to find out. They are on a tunnel vision to try to convict a man who should not be convicted. The statement about I never killed nobody, but I got something to do with that body. If the state just bothered to talk with anybody, that is a Nicki Minaj song with Jeffrey Williams. It is written by Nicki Minaj. That is on the text messages I gave, not the text message, the Instagram or Twitter rather, that I gave to the state. That is out well before this, but the state doesn't care. This was out in 2015 or 16 or 17 or 18, I can't remember, I think 18, where Mr. Williams was asked who wrote Anybody, and his response is Anybody was written by Nicki Minaj, and it was. But it was really written and sung. It's a takeoff of a song by Tupac. There's a song that it parallels, which is an inspiration. But here we are with the state. Also, I never killed nobody, but I got something to do with the body. Comes up is it's a truancy body. The state can't explain that, so they just conveniently leave it out. Your Honor, there were wiretaps on this case. Mr. Williams, it was going to come out, there was an application to wiretap his phone. The state never presented it to a judge. That speaks volumes. The leader of the YSL criminal street gang, who's been involved from 2012 until his arrest, and even according to the state, while we sit here, they never even tried to wiretap his phone. It might have been because they don't really know what his phone number is. So all these communications you're being told about with Mr. Huey, I'm not so sure the state could have gotten anybody to say that's Mr. Williams' phone. This is how the trial has gone for us. But we sit here for almost 2 years since we did our jury selection initiation on January 4th, 2023. Mr. Williams has been sitting in a jail since May 9th, 2022. This is 2.5 years waiting for the conclusion of the state's case and a verdict from the jury, and that's why he is tendering this plea. I'm telling the court this, and the court knows when you came out the first time, it's very hard for Mr. Williams. I am not supportive of what we're doing right now. I'm not against it. But I told Mr. Williams, you okay with me saying this? Yes. I told Mr. Williams that I think we're winning the trial and we should go to verdict. But he told me I can't wait another 3 months if there is any possibility I could go home because I have children that are hurting. I have things to do, and he has some medical issues that he would like to tend to. He eats out of a bag, Your Honor. He eats processed food only. He gained 75 pounds during trial. He's lost it since. But it is hard. You know, for me, it's only 3 more months. It's enjoyable, actually. I enjoy coming. It's not that enjoyable for
I think you're
Mr.
winning
Williams.
too.
He told me he wakes up. Can I say this? Yes. He wakes up every day, and it's another day in HE blank blank. Your Honor, the state is talking about, in this case, they put in social media. This honorable court was not here, but the state put in that Mr. Williams, in the indictment, Mr. Williams put out a call for murder. He put $24 million murder for hire on a person's head. That is a lot of money, and that is awful. If they would have read the chat, the Instagram chat, Mr. Williams, right above it, there's a picture of a very well-known, very accomplished musical artist who actually had surgically implanted in his forehead a pink diamond worth $24 million that day. That's what Mr. Williams would talk about. That's the type of evidence that is coming from the state of Georgia in this case. It is wrong. This is all wrong. And I know we're pleading guilty, and I know we're pleading nolo, and I know we're asking this honorable court for a certain sentence, and we'll get to it with the court's permission. But this is the type of evidence that there is. But it is holding this man hostage. And that's not really what we're supposed to do, district attorney time, in the state of Georgia or anywhere. The state then, because I opened on that, then they never bothered to put in all of the chats. Why did it take me to read the chats? In addition to that, going back to Donovan Thomas, talk about Mr. Williams involved, the state did a geofence. A geofence tracks his devices. It doesn't have to be a phone. It could be an iPad. It could be any type of electronic device that targets and is used. You don't have to be on the phone. It's the contact. If he has an app open, it'll capture it. And the state targeted the McDonald's, where they keep saying that Mr. Williams met with people there. They targeted the barbershop where, God forbid, the killing occurred. And they targeted a third location, no, 2 locations. And it comes out, Ms. Williams' devices are not there. It's exculpatory. I don't get that information. I got that because I interviewed Lieutenant Crabtree, and the results can't be found, according to prosecution. I did a motion for that. They just can't find it. That is great evidence for Mr. Williams. It would have also shown clearly that when he does go down from his house after getting this call that I'll talk about from Demise McMullen, he's not with these other people. And the expert for the state, the FBI agent who does the telephone analysis, Mr. Williams' phone does not ping off the same tower as a Demise McMullen or a Mr. Copeland or a Mr. Garlington or whomever. The state of Georgia has misrepresented for 2 years in front of this jury. They have hidden evidence. They have violated Brady. They have falsely accused Mr. Williams. Your Honor, saying that Mr. Williams gets that call 7 minutes after, the state said 6, it was 7 minutes after the killing of Donovan Thomas from Demise McMullen. Mr. Williams was already out of his home. Mr. Demise McMullen's is calling Mr. Williams. He's not even there. He's going down to meet with Mr. Kelvin Treadwell, also known as O.G. Bentley. O.G. Bentley was supposed to go to Miami, Florida. They were talking about this deal. And Mr. Williams, that day, he was given another contract. Mr. Williams, by this time, he went from zero money. He is a multimillionaire at the time. He doesn't need the Cleveland Avenue drug deals for $15. He doesn't need the shootings. He wasn't even living in Atlanta since 2018, 19, 20, 21. He came back the very end of 21, 6 months, and he got arrested in May of 2022. In his house, Your Honor, we have everyone on the witness list. There are 12 people living at that house. Mr. Williams opens up any of a car that he has. He'll rent cars for people. Any home he has, he will allow people to live in hotels because people that he knows, unfortunately, are homeless. And he gives them all places to stay, cars to drive around. He is not involved in criminal activity. Mr. Williams just got back in our country. His passport shows it. Right before he was arrested on May 9th,
What you have going on here is that
there were other people
Brian
in that
Steele
house
feels he
with the
needs to
drugs
have
and the guns. There are
counteracting
people whose the
what
guns
Love
are in their
put
names.
on the record.
They were going to come in
Because
court
this is a
and
plea
claim the
that's not
guns.
going like
Everybody
normal
else was
pleas where
doing
you
as
just
well,
say,
but
here's the
Mr.
plea and
Williams
here's the
has entered a
sentence.
guilty plea.
This is actually
Please,
kind
I'm
of
not going back
painful.
on that, but I
And
just
for
want
those
you
of
to
us who
know
believe that Brian Steele is
this
right,
case
it's even more
is
painful. But
just
you heard
wrong to do to
that
somebody
Doug
with no
thinks
bond
that
and to hold him hostage.
he wants to go home to his kids.
He
Sounds
may
like he's
not
going to
do
go
it. He's
home to
aware
his
of that.
kids
He's aware
like
of that.
tonight if we
But
ever
the state
finish.
offered him 15 years on probation. But they keep piling on these conditions. He just said, he made up his mind. He said, I'm just going to go with it. I got to get home. Judge may not let me home, but I'm not doing these conditions and admit that I'm the leader and I'm involved in the killing, and my music just promoted everybody to do it. He's not going to do that. So he did not do that. And that's how we wound up here. The state, the night of the killing, people came to Mr. Williams' home. The state tells the court, he said, lay low. What they don't tell you is right after that, he gave money to Mr. Sledge, who said, they're going to kill me. They think I did it. And Mr. Williams said, if you had anything to do with it, I don't want to be with you. And Mr. Sledge said, I just need a hotel room with my children and my bride or my significant other to get to. And Mr. Williams said, be safe, lay low. That's the lay low. In addition to that, Mr. Williams told Mr. Copeland's with the police. Hours after the killing of Mr. Donovan Thomas, Mr. Copeland goes to the police department. Mr. Williams is the person who told him to go. Mr. Copeland said, what do I do? They're shooting at my house, at my family's house, at my significant other's mother's house. And Mr. Williams said, if you had anything to do with the murder, get out of here. Mr. Copeland denied it. And Mr. Williams said, then go tell the police. Mr. Copeland said, "You want me to go to the police?" And Mr. Williams said, "If you had nothing to do with it, they think you did it. Go to the police." In addition to that, Mr. Copeland said, "Well, I'm going to retaliate." Mr. Williams told him, "Don't do that. Let 12 handle." That's on recordings. That is on recordings on January 11th of 2015 with Detective Thorpe. Your Honor, as far as Dwayne Carter, a performer known as Lil Wayne, Mr. Williams had no conflict with him. They are friends. We were presenting evidence that right before this shooting of the tour bus is April 26th of 2015, performing in New Orleans area. Then that's the area where it's Holly Grove, where Mr. Carter, or Lil Wayne, a performer known as Lil Wayne, comes from. And in order to drum up popularity and interest, people get on the internet and they start what's called rap battles, arguments.
We had another little glitch there. Aha. Pillars and columns. Okay.
Me, he idolizes me, and I love working with him. They did an album together. In 2014, they're in the studio together, making music together. It is all made up that Mr. Williams is involved. Mr. Williams gives a statement. The state refuses to put it in and then stop me, the previous judge, from cross-examining the detective. His name is Racy. He met with Mr. Williams in the DeKalb County Jail on the 15th day of July 2015. Mr. Williams is arrested that day. And there's a long interview. And Mr. Williams waives his right to counsel. He tells them, "I'm his lawyer." They say, "You don't want to speak to us? You don't have to." He said, "Well, I'll speak with you." And they asked Mr. Williams these questions. "What about Lil Wayne's shooting?" He said, "It was outrageous. I love him. That's my idol. I love Lil Wayne." "How about this battle?" He says, "It's promotion." They asked him about his rap lyrics. It's the only person that the state ever did anything about rap lyrics with. And they asked Mr. Williams, "What about the rap lyrics?" And he tells them, "It's hyperbole." He didn't use that word. He used the word, "It's made up. It's rhyming. It's made up." Not like the state is saying that I rap lyrics for real. That's not even Mr. Williams' utterance. Your Honor, the point I'm trying to make to you is what the state of Georgia has presented to this jury in this courtroom the past year has been full of untruths, and they know it. The state says that Mr. Williams had a conflict because he named an album with Dwayne Carter, and Dwayne Carter didn't like that. Dwayne Carter's interviewed. He said, "That was one of the nicest things anyone could have done to me. It shows how much he really appreciates me. It shows respect and honor, and I appreciate what he did." The state knows this. With regards to,
I'm feeling their discomfort of having standing there this whole time after love kind of usurped all the time, and concerned about
Jimmy Winfrey.
The trust he's going to have unless
What the state did is they put in a recording. It's not Mr. Williams. It's a jail recording, Mr. Winfrey and an unknown person. And then unknown person says, "When you get out, you're going to get a Porsche and $250,000. Mr. Williams not privy to that. The state looked at all of Mr. Williams' bank records, everything. They undressed him financially. There's zero evidence Mr. Williams did anything for Mr. Winfrey. The state tells you that Mr. Winfrey asked for money for a lawyer. The conversation was, and it's recorded, it was with Mr. Williams' manager. And Jimmy Winfrey said, "I need to show that I was gainfully employed for the court. Can you get me something from YSL?" And the manager said, "Yeah, if we have it, and if it's true, yes, you can have it." That is it. There's no evidence that Mr. Williams paid for anybody's lawyer, Mr. Winfrey or otherwise. In addition to that, Your Honor, the social media postings with Mr. Rashawn Bennett, also known as YFN Lucci. So Mr. Williams, the state tells Mr. Bennett on social media, I would have killed you if I didn't like the way you take care of your mother and children. That is the post. What they don't tell you is Mr. Bennett, who is also, to his credit, trying to drum up his career. Mr. Bennett is picking on Mr. Williams, who's a much higher profile artist than Mr. Bennett at that time. And Mr. Bennett is saying that he slept with Mr. Williams' fiance while Mr. Williams and she are a significant couple, that Mr. Williams' music is awful. Nobody should listen to his music ever. Mr. Williams responds by saying, we can do an album together if you want. Stop this. The man continues of how he's sleeping with Mr. Williams' significant other. And then Mr. Williams responds by saying, I would have killed you except for what you do. That is the context that they don't tell you about. And Mr. Williams did nothing to Mr. Bennett. In fact, the evidence would have shown, if we had time or we would have gone forward, that Mr. Bennett and Mr. Williams are on the red carpet receiving awards in California, sitting right next to each other and taking photographs. This is not the Jeffrey Williams. Jeffrey Williams is a known person who is all over the place. If he did something, somebody wanted him, they can find him. He is not hanging out on Cleveland Avenue. What the state is saying are not true. The situation with Mr. Bennett, so he's in the Fulton County Jail and he's housed, and there are crazy, sick, violent people, and they're on the phone, and Mr. Myrick, M-Y-R-I-C, is calling other people, supposed co-conspirators. How much will Jeffrey Williams give? He doesn't say that, but that's the theme of it, as well as Christian Eppinger. What the state doesn't tell you is that when Mr. Sumlin is asked, hey, find out how much Thug will pay me to kill Mr. YFN Lucci, Mr. Sumlin says, I don't know his number. I can't get in touch with him. He doesn't talk to me. And that's because, Your Honor, since 2015, and he means no insult, but Jeffrey Williams has had zero contact with Shannon Stillwell until this case, Kenneth Copeland, Demekian Garlington, Justin Cobb, Demise McMullen, Mr. Sledge, Mr. Murphy, all these people. This is a lie. This is a 100% lie, and that's why we tendered a no-low plea to being a leader of a criminal street gang. Mr. Williams is not a leader. In fact, if it would go forward, on Mr. Huey's phone, there are conversations with Mr. Copeland. And they both say how Jeffrey Williams is a zero, and F him. And they don't talk to him, and Jeffrey Williams never does anything for them. Mr. Huey, Mr. Williams met later. He met him closer in the time of 2020. Mr. Huey's father went through a horrible episode that Mr. Williams knew, and that's how Mr. Williams knew his son, who's Mr. Huey. And Mr. Huey's on hard times, and Mr. Huey's making mistakes. And Mr. Huey, supposedly, Mr. Williams believes, armed robbed a man named Chandler Durham, D-U-R-H-A-M. Mr. Durham is Mr. Williams. He's a fabulous record engineer. And Mr. Williams states, give him back, tell him to give back the property or he's going to die. The state puts that as an overt act. No one dies. The property doesn't get returned. Mr. Huey ignores Mr. Williams. The state told you today that Jeffrey Williams sent Mr. Huey a posting that Mr. YFN Lucci is going to be performing on January 19, 2020. That's not true. Mr. Huey sent that to whoever phone that was. And all it says is slat and slatty. Well, I went out to the places that Mr. Bennett was supposed to perform. There's no shooting. There was no fight. There was nothing to report. There's nothing here. In addition, the state says same thing on September 12th, September 2nd, 2022 on Mr. Huey's phone. I'm not conceding that was Jeffrey Williams even having a conversation with him, but even if it was, it doesn't show anything. It says Slatty, lay low. Lay low means don't do anything. Get out of the way. That is what it is. That is Mr. Williams' role. Mr. Williams, there is evidence in the record, and there would have been more. He takes people on tour with him. He takes people to the mall with him. But when they do crime or do things to people, for instance, there was a prostitute, and several people gave that prostitute money, $500. And the prostitute, at the end of the $500, getting $500 from several people, had sex with a person, and then she was armed robbed. So all the money came back. Mr. Williams wasn't involved in that, but he heard about it. He made those people find the prostitute and repaid her every dime. People stole from stores that Mr. Williams found about. He went to the stores and he repaid all that. He didn't steal anything. He doesn't need to steal anything. Your Honor, Mr. Williams stands with Elton John. Elton John called Mr. Williams the next coming of John Lennon. Mr. Williams is unbelievable talent. He's not just a rap artist. In fact, when he's interviewed in 2017, he gives a statement and he says, I had to learn rap. He grew up in a house.
Okay, we're going to continue running this. I'm going to let you all see it. And then Michael Bryan will be back tomorrow to discuss. Let me just say to you, even if YSL gets time served tonight from the judge, or the judge may put off the sentencing until tomorrow, he won't be released tonight because the jails can't do paperwork to get someone released at this time of night. But let's continue listening. Michael Bryan will probably see you tomorrow. I may see you tomorrow also, and we'll have to see where Doug Weinstein stands with his client then too. Thanks for watching. Stay with us.
House learning other forms of music. He likes all music, but rap hit in his community. And his community raised him. They supported him. They came out to him. They made him get into establishments. And once the establishment saw all the people come out, he got more establishments. And then he went out of that little area in Atlanta to other parts of Georgia, and then to all the neighboring states and throughout our country. And he has performed on every continent but one. He has performed in front of, being the headliner, 300,000 people at one time. He has a real life and career. He is not the leader, and he is not worried about buying jewelry that is stolen. Mr. Williams is actually innocent. I'm not trying to corrupt our plea. That's his plea, and he's entitled to it, and he wants it, and he embraces it. But to me, this is a wrongful prosecution. This is outrageous.
All right, so you're pleading guilty, or your client is pleading guilty to counts 57 through 62.
It's all true.
Do you
Yes, there's a
concede
factual
there's a
basis.
factual basis for those counts?
Yes, I concede that.
Okay. All right, I mean to interrupt.
Data brokers
Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22 and a half years. On count 56, Your Honor, that's the leadership of a gang, NOLO plea, 20 years to serve 5 years commuted to time served, consecutive to all other counts. On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years commuted to time served, concurrent with count 1. With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count 1. On count 59, which is violation Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count 1. On count 59, Your Honor, which is violation Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count 1. Count 61, 5 years of probation. It's a firearm count, consecutive to the other counts, consecutive to before count 56. And then count 62, 10 years to serve, commuted to time served. That should be a total sentence, Your Honor, that we are respectfully requesting the court to consider. I believe it's 45 years to serve 5 years in prison, commuted to time served, 40 years on probation, credit for the time already served and commuted time served. As I said, after 3 years of probation, the probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated. Mr. Williams asked the court for house arrest for 3 years as part of his sentence, but house arrest specifically defined that Mr. Williams will be in his home or at any lawful employment, touring, studio, performance, business meetings, and the like. Wear an ankle monitor for the first year and pay the costs of same, and the company must be approved by probation department, and the ankle monitor to be affixed within 10 days of hopeful release from custody. Mr. Williams cannot possess a firearm, but he can be around licensed security who are armed or other persons who are lawfully carrying a firearm with a license. And that would be knowingly for Mr. Williams. Mr. Williams can transfer probation outside the state of Georgia. He has residences in the state of California. He has studios in the state of California. Mr. Williams be allowed to travel throughout our country and the world for lawful work-related industries. Mr. Williams wants to perform. He's going to do this anyway, Your Honor, but we made it part of the sentence. At least one concert each year at a venue, if they'll have him over holding 10,000 people, if that is workable for the venue and Mr. Williams' management, and he is going to donate all of the profits that he makes to a 501c3 charity. Mr. Williams wants to pledge $100,000 for the next 3 years to the Fulton County Sheriff's Office if they will hold an illegal firearm buyback to buy back firearms that are not supposed to be on our streets. Mr. Williams does not wish to go near the Cleveland Avenue area, not to insult that area at all, but it is just not a good idea under this circumstance. And he can drive on the highway, but otherwise not come within 1 mile of the area that we call Cleveland Avenue, and we can give the exact dimensions of that area. Mr. Williams must perform 100 hours of community service per year for the next 3 years as designated by probation department. Mr. Williams can associate, and this was agreed to previously, with people who are convicted felon or alleged gang members solely for lawful purpose of making music.
I see Ms. Love shaking her head, and I think it's fair to establish that until the entirety of the negotiations were agreed to, it was all up in the air.
Sure.
That may have been something y'all had already hammered out, but it's not anything they're bound to.
Absolutely.
Fair. Okay.
I agree with that. Mr. Williams can have no contact with any of the supposed victims, and there was an Exhibit A attached to the state's proposed plea agreement, negotiated plea agreement that was sent to you. So we adopt that Exhibit A, but we can give it to the court if you need those names. And Mr. Williams have no contact with any of the co-defendants in this indictment, with the exception of Mr. Quantavious Greer, that is his biological brother, as well as Mr. Sergio Kitchens. He's a phenomenal artist. He goes performer known as Gunna, Gunna. Mr. Williams and Mr. Kitchens are contractually obligated, and they frequently perform music together. Your Honor, any other conditions that this honorable court deems appropriate? I want to thank the court for all your time. Always, I want to thank Ms. Percival for everything she has done. I want to thank Mr. Williams for allowing me to stand with him. And I really never thought we would be here, but this is his decision. I want to thank the Honorable Keith Adams, who may want to speak, Your Honor, but I can never imagine a better lawyer than Keith Adams.
Mr. Adams, do you want to add anything to the record?
Your Honor, I don't know that there's really much to add. Mr. Steele has represented to the court, I think, fully and thoroughly the breadth of our knowledge of the case. Mr. Williams's background, I think the court has not just heard it from Mr. Steele, but has had the opportunity to sit here and hear some of the evidence and kind of get a feel. You've had a chance also to observe Mr. Williams and then get a feel for him, his background, and so forth. You know, the only thing I can say about Mr. Williams that hasn't been said is that he comes from an area. You might have heard throughout the course of the trial that there was an album, a concert tour. We came from nothing. And that is true. Mr. Williams came from, you know, I hate to use the word abject poverty, but that really is the case. Came from an area where there was a significant amount of crime, where, as you've heard, he's had tragedy in his life and has observed tragedy in his life. And he has gone through a good bit. He has been involved in a lot, but he has raised himself up. He has done the best he could and has done phenomenally well, and is, I think, an inspiration to a lot of people from that community who look to him and see the success that he has gained and have been fully supportive of him. But he finds himself here. He's in front of you. He is tendering this plea because he accepts responsibility. You have heard everything Mr. Steele has had to say. I can only ask that you follow what we have put before you. You also have, I believe, the paperwork that was given to you by the state, which kind of gives you some idea of what they were looking for as well in terms of conditions on Mr. Williams if we were to have reached some sort of agreement. And we ask that if you feel that there is anything within the state's proposal that might be appropriate in terms of sentence for Mr. Williams, that the court please feel free to do that. There is nothing that he puts himself before the court. And I think 2.5 years sitting, going through this process, challenging the process, but now standing before you and asking that you consider everything and sentence him appropriately in the way that we've requested. I'd simply ask you, I join Mr. Steele and Mr. Williams in asking you to do the same. And I thank you as well, as Mr. Steele did, for your patience with us and for bringing some order to the proceedings that candidly was needed. So that's all I have to say. I thank you again, and I ask you to consider everything that's been put before you.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full responsibility for, my crimes or my charges. I want to say sorry to my family, my mom. My mom got 11 kids. I can't say all their names, my managers, my kids that's not here. Really everybody that got something to do with this situation, I want to say sorry for just having so much time invested into this, and I am a smart guy. I am a good guy, and I really got a good heart. I find myself in a lot of stuff because I was just nice or cool, and I understand that you can't be that way when you reach a certain height because it could end bad and they don't really have to have nothing to do with you, but it could end bad, and it could, you know, fall on you. And I know the choice is yours, it's up to you, and I hope that you allow me to go home today and just trust in me to just do the right thing and never see you again unless it's at a, you know, bar in the future or something. Just out of this type of situation, I promise you I won't ever be in this type of situation again. I'm going away. I've learned from my mistakes. You know, I come from nothing and I've made something, and I didn't take full advantage of it. I'm sorry. Through these last 2.5 years of my life, you are really, truly, honestly, the best thing that has happened to me, because you made everything fair for me and everybody involved on both sides, you know. I'm sorry to the sheriff, you know, everybody, for just having to put extra time in. I know y'all got paid more money, but I'm sorry for y'all having to put this extra time in to be away from y'all family, you know, and I just hope that you find it in your heart to allow me to go home and be with my family and just do better as a person. I know what I bring to the table. I know what I am. I know the heights I've reached. I know the impact I got on people, period, in the community, you know, all people. I learned that late, like these past 2 or 3 years of my life, I kind of learned that late. And maybe it was because I was, you know, probably on drugs or anything, I don't know. But I have came to my senses and I understand what I mean to this world. But I am a good guy, you know. I don't mind doing stuff like, you know, like free shows, and I always did that. You know, I did free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million on a free show, and I gave it all to single parent charity. And I did like 2 or 3 shows that made like $700,000 a piece, and I gave it to the breast cancer organization. Like, you know, I do things like I put millions of dollars back into my community for real. I really did. I did more than anybody ever did from my side, you know. But I understand, you know, rap lyrics. I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that, and I promise you, I'm 100% changing that. You know, it's just, I'm older, I'm grown now, you know, and it's just like, I'm smarter. It's more things to rap about. Like I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever.
Well, I appreciate it. And I appreciate that you do realize how much of an impact you have on people. I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do. Look at him, he's a millionaire. I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are, you know, far the most likely outcomes. And, you know, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do. And that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, you know, I mean, he might have rapped too in this day and age. I don't know, but I know you're talented. And even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, you know, I know that happens for protection sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go on. So it is not lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, you know, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration and crafting my sentence. And in permitting a NOLO plea to the RICO count and one of the two gang counts, I would not be permitting the NOLO to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged, I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count one, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count one, but I am going to backload. Oh, I'm sorry, that is not commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation. If you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served concurrent with count 1. 60, 5 years to serve, commuted to time served concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is pursuant to OCGA 17-10-1, subsection 2, A2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do it mean?
Can I have a second, Your Honor?
Sure.
Like the judge. Thank you, Your Honor.
All right. You had enough time to talk with your attorneys?
Yes.
Okay. All right, special conditions of your probation. After 48 hours from your release, you are to stay away from the metro Atlanta area, and that's defined by the U.S. Census Bureau. It may change, but you can look that up anytime to figure out what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined the same way that you all were contemplating it when you were negotiating. You can get here up to 24 hours prior to any such event, and you need to leave within 48 hours after any such event. In addition, during each year of your probation, I'm going to require that you come to the metro Atlanta area and make a live anti-gang and anti-gun violence presentation 4 times a year, each year of your probation, at a grade school, a middle school, a boys or girls club, anything like that, that type of group. And if you want to, that presentation can include a benefit concert, and these presentations may count towards your required community service hours, which I'm going to impose, that during each year of your probation, you perform 100 hours of community service. You are, and this is required by the fact that there's a gang conviction. You shall not knowingly have contact of any kind or character with any other member or associate of any criminal street gang. Exception to that, if your brother is a member of any street gang, I hope you talk him into getting out of it. Quantavious Greer, and then also Sergio Kitchens, as long as you are contractually obligated to him. That is going to include anybody who is named in this indictment, except as absolutely necessary to conduct the lawful business of your musical career, and to any extent that the state is not agreeing to the exception for Mr. Kitchens. In the event that that part is not enforceable because it is only a portion of a special condition, going to provide that that be severable from the rest of this, and I'll put some case sites in the Senate sheet for that. You are in no way to promote any criminal street gang or any criminal street gang activity, including on any social media platform. You are not to utilize any hand signs, terminology, or language that promotes any criminal street gang. You are not to participate in any criminal street gang activity. You are not to knowingly engage in any contact with any of the victims that are listed in this indictment or with any of their family members. And you may not have in your possession or with arm's reach any kind of a firearm because you're going to be a convicted felon. And that is, except I know that you have security and you need security. You can be within arm's reach of a firearm that is in the possession of either licensed law enforcement or licensed security personnel that are in your security detail or anybody that you're performing with. You are to submit to random drug screens and not use any drugs unless they are prescribed for you by a licensed physician. You are to execute a Fourth Amendment waiver that will permit the search of your person, residence, vehicles, and electronics for any firearms, any criminal street gang paraphernalia, or any illicit drugs. And as I mentioned, with regard to one of the first of your co-defendants from this trial, at least since I've been involved, to plead guilty, our Uniform Superior Court rules instruct and provide that it is absolutely proper for a judge to grant leniency in sentencing when, quote, the interests of the public and the effective administration of criminal justice are served, unquote. And I think that this plea is in the interest of the public and in the interest of effective administration of justice. Have been trying to ensure that to the extent I can, this trial also abides by that. It's been challenging at certain times. I find your plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I accept it as such. I also need to inform you that your attorneys were going to represent you through either the last day of this term of court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things and to do and continue to do things that benefit your community and especially help young people to stay out of criminal trouble. And unless there is anything from counsel other than that.
I have one matter, Your Honor. The other items?
Right.
Can you also consider, God forbid, there's a serious medical condition of a person that
In
is,
his immediate family,
yeah.
certainly, we can add that. And I also meant to mention, because I know you do travel all over in order to pursue your career, that it's permissible for your probation to be transferred to out of state, and that has to be done through probation, but that is fine with the court. And you may also keep your, nobody's mentioned it, but keep your passport and travel out of state and internationally to the extent that you need to do that for business purposes as well. All right, Mr. Body.
Yes, just very briefly. Thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by what has been discussed by both parties here today, to make a brief statement as she believes that they fall within the exception or within the bounds of Marcy's law, if the court would allow. I understand the court made a ruling earlier as it relates to that, but she wants.
All right, thank you. And I appreciate, well, I cannot even begin to understand what they must, anybody must be going through when they lose a family member to violence or criminal violence. Mr. Williams himself has expressed his own sorrow to the family. I, again, am going to stand by my belief that the appropriate time to hear a victim impact statement from them is at the close of the trial that contains the murder count with regard to their family member. All right, thank you. Okay, court is adjourned. Good luck to you. And I'm going to have there better be no violations, but if there are any, you're coming back to see me.
Yeah.
All right.
Thank you, Your Honor.
Hey,